This program is not intended to replace professional legal advice or representation. If you have a legal concern, you are strongly encouraged to seek the advice of an attorney.
Hi, I'm Yanique Otto, attorney at law in South Florida with the Otto Law Group. Thanks for joining us for this episode of Now You Know the Law. So, you dated for a few years, got married, had some kids, and now for whatever reason, you've chosen to go your separate ways. You filed a divorce, go through the process, and the judge declares you a single man. 2 years after, you get married again and start a new family. Not long after, you're in a car accident and you die. Pretty much the only thing you've left to provide for your new family is a life insurance policy valued at $250,000. Your ex-wife presents a copy of the policy, which of course she kept, naming her as the sole beneficiary. Livid, your current wife calls up the insurance company to find out whether you had changed the benefit of the policy to name her as the beneficiary, and sadly finds out that you did not. She's upset at this point and wants to know, will the ex-wife basically get all the money from the policy, and will she and the kids be left high and dry? Here's what you need to know. Well, actually, you're gone, so here's what she needs to know. She can put her mind at ease. As of 2013, a new Florida law protects the new wife in this situation. Let me break it down for you. Whenever there's a life insurance policy that names someone's spouse as a beneficiary, if there's ever a divorce, the law will automatically step in and basically knock out the former spouse as the beneficiary unless the parties have agreed otherwise. So let's just say he completely forgot that he had the policy and he just went about life as usual and it never came up until his death. At that point, new wife would be in luck and old wife, not so much. She won't get anything under the policy unless hubby had gone back after the divorce and specified that he wanted her to continue to be the beneficiary. Now, the obvious question is what happens to the policy payout if the ex-wife is the named beneficiary and hubby did not make a change to it, but the law says she doesn't get the money? Well, I'm glad you asked. What happens is that the law will treat the benefit as passing through intestacy. This means that as to the life insurance policy, it will be as if the husband died without a will, and the amount of the policy will pass to his next of kin under the Florida laws of intestacy. Now, intestacy laws are fairly complicated, and I'll be doing an episode on that soon. But in our current example, the money would basically go to the new wife and kids, and old wifey gets zilch, zero, nada. So here's the bottom line. If you're getting a divorce, be sure to discuss with your attorney what you need to do with respect to your life insurance policy, your will, your trust, and any other similar documents, because you want to make sure that your money goes where you want it to go after you die. Thanks for joining us. We'll see you next time. I'm Yanique Otto, and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.